Hello, I'm Andrea Riley, and this is my partner Yvette Thomas, and welcome to our presentation on practicum students, student teachers, volunteers, and substitute teachers. Now, we decided to discuss this topic because we feel that many times teachers find themselves in these legal situations which could have been avoided had they had followed proper guidelines. So now Yvette will discuss, the highlights of these certain topics. So Yvette?
Now what I'm going to talk about is practicum students, student teachers, and substitutes, as well as volunteers. We all recognize that they're common in the school districts, and they prove very valuable to the curriculum. However, they can be held liable for their own acts and omissions. In some situations, even an absent teacher can be held accountable for injuries that occur. Our cases today will show examples of why following guidelines will keep students safe and minimize risk of negligence. Today, Andrea, my first case is going to discuss student teachers. And the title of my case is Brahadachek versus Milliard School District. And this case went all the way up to the Supreme Court in Nebraska. This happened back in 1979, but keep in mind it has about a 3 or 4 year history. First, I'd like to begin by giving you a background. In this situation, we have David, who's a 14-year-old student in the 9th grade. David was absent from class on the first day of instructions that golf was taught. When he came to class on the second day, he was not given any instructions on exactly what to do when golf. Keep in mind that on the day of the incident, it was held in the gym due to bad weather. What actually happened was there was 2 teachers that were actually assigned to the students. There was about 57 students total. It was a co-educational class. We have a female teacher that was present, and we also have a male teacher that was present. Keep in mind that the male teacher was actually the student teacher in this case. On the day of the incident, David walked up to the mat, and he was unaware of exactly how to swing. What he did was he asked a fellow student to help him. What, of course, David did not realize is the day before, when he was absent, all of the students already had the instructions on how to swing, how to grip, and the safety procedures in golf. So in asking the student didn't have any problems with actually demonstrating. The student told David, "I'm going to take 2 swings, and then I will hit the ball." Before he actually took the swing, the student remembered the safety precautions, turned over his shoulder, and looked. He didn't see anyone at that time. When he swung, he accidentally hit David in the left side of his head. He was unaware that David had moved closer to him, and that was very unfortunate. David was knocked unconscious and died 2 days later. In the suit, the plaintiff, which is David's mother, she filed a wrongful death suit against the district, claiming negligent supervision. Unfortunately, the school district said that they were not negligent, actually included the classmate as a cause to David's accident, and even went so far as to say that David was contributory negligent in this case. The trial court ruled that the district was negligent in its supervision of the class, of the entire class. The classmate was not an intervening cause, and David in no way contributed towards his negligence. But what I wanted to mention here is that perhaps you wondered exactly where was the teacher. The teacher was just a few feet away working with an individual boy who needed help. So what exactly was the court saying when it said that the district was negligent in their supervision? It was saying that the student teacher was present, true, but he was a few mats away assisting another boy. What this says in the court's mind is that this was ineffective supervision. It says that we need general supervision, not just specific. It was also saying in this instance, in a 9th grader that had no knowledge of what golf actually entailed, we as teachers should have our duty to anticipate. And the key word here is to anticipate danger. The student teacher in the case, when the evidence was presented, he acknowledged that he actually had no instructions from the teacher that was absent or the female teacher that was in the gym at the time. He also mentioned that they failed to give him a lesson plan, so he had absolutely no guidelines of which to follow. But having said all of that and presented the evidence, the courts are still saying that we should know something could have happened. We should have once again anticipated that danger was there, that we should know enough to keep our students safe. Of course, the defendants appealed the case. They said, look, there was insufficient evidence of negligence, and that the courts also failed to hold the classmates negligent in this case. The Supreme Court ruled on this case, and their review said that there was a lack of supervision which caused David's death, that David was in no way contributory negligent. He couldn't have been because he was unaware of the game. He had absolutely no knowledge of exactly what was going on. The courts awarded David's family special and general damages and also costs to the David's estate. The decision affirmed for the plaintiff. What I've learned here, Andrea, is that teachers must be in a position to be able to see all of their students. We recognize that there will be students that will need help, and yes, we want to offer them help, but our eyes have to be broad. We have to be able to see across the entire classroom. And it also teaches me that certified teachers, although they are absent, they are still responsible for giving instructions to the student teachers. These instructions are very important, and they can be found in the lesson plans if one had been given. And my biggest one is regarding general supervision. Give general supervision and not just specific.
Also, with the lesson plans, had the teacher left that available for the substitute teacher would have probably known that he needed to go over safety rules and proper equipment. So it's an unfortunate case that you have, Yvette.
Very.
Now, I have a case that happened in Louisiana in 1999. Here we have Darrell Jackson, who was a 327-pound, 16-year-old who was participating in a PE class which was conducted by a substitute art teacher at Frederick Douglass High School, Senior High School. Now, evidence indicated that inside the gym was actually about 90 degrees hot, and it was very, very poorly ventilated, as in there was no AC, and there were no records indicating that there were outside doors to allow fresh air to come inside this gym. The art teacher has the students playing a game of basketball, which Darrell had actually participated in for about 20 minutes. After his 20 minutes of participating in the basketball game, he decided to take a rest because he was complaining of a headache. So while he was off to the side, he actually collapsed and began to have a seizure. Medical personnel was called, and he was then transported to the hospital where he was unfortunately pronounced dead. Now, Darrell's mother actually filed action for wrongful death of her son against certain school employees, which included Manuel Jackson and Vincent Nzinga. She also went after 2 insurance companies, the school itself, Frederick Douglass Senior High School, and the Orleans Parish School Board. In June of 2003, the defendants motioned for what they call an in limine, which is basically asking for the judge to disregard evidence of that trial. Now, the reason why the defendants probably wanted to disregard information or motion for the in limine was to exclude expert testimonies from Dr. Douglas Singer, who was a cardiologist from Florida, and Dr. Lucinko, who was a retired PE professor from New Jersey. And the trial court actually felt that the defendant's motion for the in limine was inappropriate, and they rejected it. So the trial court ended up awarding the plaintiff $700,000 in consortium. Consortium is when you have any type of union or any type of relationship with the deceased. So they awarded the plaintiff $700,000, and also they awarded the plaintiff $60,000 in survival damages. The defendants appealed, and the trial courts actually reconsidered monetary value and lowered the plaintiff's consortium from $700,000 to $500,000, which the plaintiff still kept the $60,000 in survival damages. Then the defendants felt it was appropriate to defend the trial court's judgment. And the defendants brought up several reasons for that. One being that they felt the trial court abused its discretion in excluding testimonies from Dr. Singer and Dr. Lucinko. The court felt that the defendant's motion for the eliminate, as I mentioned before, was relevant to the weight and credibility of the testimony. The defendants tried to say that Dr. Singer's testimony should also be excluded from the trial because Dr. Singer, his evidence relied on the police reports that measured the temperature of the gym at 4 o'clock as opposed to 12:30 p.m. when the incident actually occurred. Now, that does bring up a valid point on wanting to exclude Dr. Singer's, testimony. However, the trial court found that error to be harmless because there were other independent sources that found that the gym was actually 90 degrees at the time of the incident. The plaintiffs also failed to prove that the duty was breached, is what the defendants felt. Well, the courts felt that the teacher has a duty to protect or supervise the children in the class at the time. And the courts actually stated that the teachers have the duty to exercise reasonable care and supervision over students in their custody and therefore must conduct their classes as not to expose the students to injury or unreasonable risk of injury. Now, Darrell, in our particular case, is 327 pounds and was asked to participate in a poorly ventilated area for 20 minutes before breaks were even given. It was also found that the substitute teacher did not require water breaks and that the substitute teacher actually participated in the game of basketball. Now, once a substitute teacher or any teacher is an active participant in the game, they are no longer supervising the class, which the courts found error upon. The defendants also felt that the plaintiffs failed to prove that the conduct of the board or the employees was the legal cause of death. And the trial court concluded that this issue was a finding of fact, or in other words, the court felt that they had enough evidence to say that our ruling is correct and that we are going for the plaintiffs in this verdict. Also, I would like to make it known that Dr. Singer's testimony revealed that Darrell's death could have been caused due to heat illness, specifically heat stroke. And Dr. Singer also noted that he might have suffered a cardiac arrest due to that heat stroke. And his signs of the stroke was the headache and having the actual seizure. Darrell's weight of being 327 pounds in a poorly ventilated area and working on strenuous activities actually predisposed him to these heat illnesses and ultimately caused his death. So here in this case, the judgment was affirmed for the plaintiff.
That was very unfortunate.
Yeah, it was pretty sad. I mean, any gym in Louisiana, September is not considered summertime, but 90 degrees is pretty hot for anyone to be in there, not just a 327-pound 16-year-old.
And which makes also a concern, was he really mentally, physically, emotionally ready for the activity of which he was participating in? But I have another case I'd like to present to you at this time. Now, this case is regarding substitute teachers, and the title is the Miami-Dade City School Board versus ANSR and JN. This goes to the Court of Appeal in Florida in 2005. What I learned about this case is they used initials because it is children who are involved in order to protect their identity. I'd like to give you a summary of exactly what happened, and the details are very small or very limited regarding it. There was a kindergarten boy who sexually assaulted another kindergarten boy. The substitute was unaware of the developmental problems and the sexually aggressive behavior of the student. The substitute was also unaware of the school's policy regarding the bathroom pass procedures, where there was only one student at a time to actually go into the bathroom. Now, when I first reviewed this case, I placed myself in this situation. I've been a substitute before, and when I go and I follow protocol, I enter the school, I introduce myself, I sign in. I ask for directions on where my classroom might be and if there's anything that I might perhaps need to bring with me into the classroom. I wouldn't think at that time, or I wouldn't know enough at that time to ask, are there any school policies or procedures that I need to be aware of before I leave? I wouldn't know enough, Andrea, to really ask about that. In this suit, the parents of the boy brought an action of negligence against the school district, and it said simply that the district failed to warn the substitute teacher of the developmental and sexually aggressive behavior of the boy, that they also failed to mention the policy on the bathroom pass procedure. How was she to know that only one student at a time was to go? The parents also brought a suit against the school board regarding the fact that the school did not separate the boy from other students. Also in this case, there was a psychiatrist who gave a testimony, and his testimony stated that the young boy did suffer post-traumatic stress syndrome as a result of the assault. Now the defendants, the school board, they entered their judgment, and they simply said that the court should have entered a judgment in their favor. They were simply saying that they weren't negligent, that they didn't prove negligence. And also the school board says that they wanted the jury to actually look at their procedure for standard of care. Now, standard of care, from what I understand, simply says that this is the care that a reasonable person should exercise. So now we go to the civil trial, and in the civil trial, the trial found the board negligent. They awarded the plaintiff past and future damages as well. So once again, I ask, what exactly was the court saying? The court said the board breached its duty of care. Of course, the board wanted to mention the standard of care procedures that they have for their students, but at this time, that did not protect this boy. It didn't protect that student. That the board failed to share all of the information that they had that could have possibly helped this substitute teacher keep this young boy safe. Once again, the defendants appealed. What was their claim? Their claim was that they weren't negligent and that the lower court erred. What was the error, you may ask? They say that they didn't allow the jury to see the standard of care, which is the special instructions that they have regarding their care for students. And also that the court was allowed to, the jury was allowed to use mortality tables, and that it was introduced to the jury, and they were told actually how to use them, and that there was no proof of permanent injury to this boy. The case went on to the Court of Appeals. The Court of Appeals simply said, the board, you're not entitled to judgment. The trial court did not err. They didn't err in the standard of care instructions, nor did they err in giving the mortality tables to the jury. You simply breached your duty of care, and that there is no evidence to support the permanent injury. Now, regarding the permanent injury that we're mentioning here, it was important to understand that when the psychologist testified, he said that yes, the boy suffered post-traumatic syndrome, but that also in the future we can expect him to have some effects of this attack, especially around his age of puberty. So the trial court acted properly, and this is exactly what the Supreme Court said. The decision, plaintiff affirmed. Now, once again, I've been a substitute teacher before, and what I've learned in this situation, it is that if someone had just taken a few moments to inform the substitute teacher of the details of the student, this whole incident could have been avoided. It brings into mind that substitute teachers or anyone who's teaching needs a lesson plan, and a lesson plan needs to be detailed enough that it will cover incidents like this in order to anticipate or foresee and prevent injuries.
That's a very tragic case.
Yes, it is.
The fact that a kindergartner had to deal with such circumstances at such a young age is just very traumatizing.
Yes, that it is.
I have another traumatizing case. Here in New Mexico, in Clovis School District, we have Sarah Upton, who is 14 years old. Now, Sarah has had asthma since she was 3 years old. So when the attack is coming on, she kind of knows what to do, and her parents are also fully aware that she is capable of doing the necessary actions in order to, live. So Sarah is 14 years old, as I mentioned before, and she's going into high school. In high school, in a lot of different states, a lot of different schools, PE classes are actually mandated. So being that Sarah does have asthma, the parents took all the necessary steps in order to make sure that while Sarah was in school, that she is safe. The first step the mother took was going to the school and actually speaking with the PE teacher. Now, the PE teacher agreed that if any of the activities became too strenuous for Sarah, that she would actually limit Sarah's participation. The mother took it a step further and created an IEP, otherwise known as an individualized education plan. And that is basically an agreement between the student and the teachers and the parents, indicating that there are special services needed for that particular child. The mother also took it a step beyond that and gave verbal consent to the school personnel to contact medical personnel if an attack was to happen in school. Now, during this particular day, Sarah was in PE class. This PE class was being covered by a substitute teacher, and the substitute teacher required the students to perform drills and sprints that was considered more strenuous than any other day. Now, Sarah began to feel uncomfortable. Her breathing started to become harder, and she actually became red in the face. Friends also indicated that she saw that they saw Sarah's lips turning blue. Sarah appropriately went to the teacher and asked to stop activity. Surprisingly, the teacher said no, and Sarah had to continue on with the exercises. It wasn't until after PE class that Sarah was able to take her inhaler. So while Sarah was in her next period class, around 2:28, as records show, it was when Sarah had actually slumped over in her desk and passed out. At 2:29, the teacher of that class actually called the main office for assistance and attempted to give Sarah her inhaler treatment. At that time, another teacher and the school secretary arrived to the classroom. I want you to realize that the secretary actually had nurse training. It wasn't indicated if she was an actual RN or if she was in the process of becoming a nurse, but all we know is that she actually had nurse training. The secretary checked Sarah's vital signs and asked the office to call 911. Just keep in mind that no CPR was administered or any other emergency protocol procedures. Sarah was then placed in a wheelchair and then taken into the hallway. Why, I'm unsure. I'm just as confused as you guys are. Evidence shows that first contact with 911 was actually 15 minutes after Sarah's onset of the attack. And the only reason why medical personnel was contacted at that time was because there was a policeman in the hallway who saw Sarah's condition and called for medical personnel at that time pretty much immediately. Evidence also shows that around that time, the school had also called for 911 to be at the school. By the time medical personnel had arrived, Sarah had stopped breathing, and attempts to revive her were unsuccessful, and she had died from her asthma attack. Now, the parents, rightfully so, filed for wrongful death against the Clovis School District in New Mexico and based that on negligence on the school employees, which they felt contributed to Sarah's death. Now, the school district motioned for tort immunity under operation or maintenance of the building. The district court and the Court of Appeals actually agreed with the school. And the district court and the Court of Appeals actually granted the school certiorari, which is a judicial review, to explore whether or not statutory waiver of this immunity for negligent acts committed under the tort was actually applied in this situation. Now, the Uptons, they brought forth several claims to help strengthen their case. First being that they felt that the school put Sarah and other situated students at risk, and saying that they should have followed protocol, which I will get into later. Negligence, the family felt that the school was negligent and they were the actual cause of Sarah's death. They felt that the events occurring prior and leading to the asthma attack and the events occurring after the asthma attack began were reasons for Sarah's death. The parents also felt that the school had written and verbal knowledge of Sarah's condition and appropriate procedures should have been done to possibly save Sarah's life. The school failed to advise the substitute teacher of Sarah's condition, and perhaps if the substitute teacher had known that Sarah had asthma, the substitute teacher would have probably lessened her activity or told her, go to the side and come back when you are ready. But instead, the substitute teacher made Sarah continue the exercise, and those actions are believed to have led to Sarah's attack and death. The family also felt that the school was negligent in failing to respond to Sarah's attack. It wasn't until 15 minutes after that 911 was actually contacted, and the school had verbal consent from the parents that in case anything was to happen, to contact medical personnel immediately. No CPR was administered, and the confusing part about it was that she was actually placed into a wheelchair and wheeled out into the hallway. What I found interesting about this case was that the parents felt that they could compare Sarah's condition to a fire occurring at the school. The parents pretty much said that if a fire occurred at the school, there are certain policies and procedures that you need to follow. There are signs posted up in order to safely have the kids evacuate the building. Well, they felt that Sarah has special needs. She has asthma, and in order to keep her safe, there are certain things that need to be done to keep her alive and keep her well. So I thought that was interesting. And they felt that the school district failed to follow through on its safety policies for students with special needs and students in acute medical distress. Therefore, they felt the school was negligent in operation of the school. So the Supreme Court heard all this, and they actually reversed and remanded the Court of Appeals. Reversed and remanded pretty much means that they need to take it down to lower courts, and lower courts need to review all the evidence of the trial. And the Supreme Court felt that if the jury agreed that the plaintiffs were right and their case was strong enough, that the school will actually be found negligent in the operation or maintenance of the building within that tort immunity that they had originally claimed for. So we can only hope that the jury did agree. There hasn't been an update on the case, but hopefully, I think the plaintiffs have a pretty good case here, and that, if the jury did hear, I'm sure that they will side for them, and the school will be found negligent.
I believe they have a pretty good case as well, and I hope that they actually do that.
Yeah. Yvette, I think we learned a lot here today. I feel like our viewers can take a lot of information back with them and hopefully use it in the future.
And I believe they will too. And I believe what we need to really concentrate on, of course, with student teachers, like in the cases that we presented today, is that they need to be provided with a lesson plan. And also that they need to be provided with active and ongoing supervision. Remember the general supervision, not just specific supervision.
Also, I feel that it's important to know the medical status or the medical condition of your students, so that way you can act appropriately if an emergency situation was to happen.
Yeah, that's true. And regarding the lesson plans, of course, we know with the lesson plans they should be very detailed, and they should list any behavior issues that you have, any warnings.
Safety procedures, you know, equipment that will be used, rules and regulations for that class, all necessary actions that a regular teacher makes in the beginning of the year. The substitute teacher, student teacher, what have you, should also be very knowledgeable of that as well.
And I agree. Now, this is our presentation, and we hope that you learned a lot and that you can take this information, use it as a shield and a guide. We wish you well out there, and thank you, and have a good day.
Thank you.